This is a Harlan Institute FantasyCast for Rehberg v. Paulk. This case arose in 2003 when Charles Rehberg began sending anonymous faxes to Phoebe Putney Memorial Hospital, wherein he criticized the management and accused them of financial dishonesty. The district attorney of Dougherty County, Georgia, Ken Hodges, agreed to investigate the anonymous faxes as a favor to the hospital management. Hodges, along with Chief Investigator James Paulk, looked into the case and believed Rehberg to be responsible for the faxes. Paulk and Hodges fabricated subpoenas, which are court orders to compel the disclosure of evidence, and presented them to Rehberg's telephone and email providers, hoping to uncover evidence to support their suspicions. When Hodges assembled a grand jury and charged Rehberg with assault, burglary, and harassment, Paulk took the stand and testified that Rehberg had broken into a doctor's house and assaulted him. However, there was no evidence to support these statements, and Paulk eventually admitted that they were untrue, which led the prosecutor to dismiss the case against Rehberg. Over the next year, Rehberg was indicted with assault and harassment 2 more times, with Paulk presenting the same false testimony at both hearings. Again, the indictments were dismissed for a lack of evidence. Rehberg filed a lawsuit against Paulk and Hodges for charges such as malicious prosecution, fabricating evidence, and false testimony. But Paulk and Hodges argued to the court that they could not be sued for their actions during the investigation and indictment of Rehberg because they were acting in their official capacity as government officials and therefore have absolute immunity. The district court disagreed, holding that government officials traditionally do have immunity from suit, but because Paulk took the stand and acted as a complaining witness in the case, he could be sued by Rehberg. The Court of Appeals of the 11th Circuit reversed the district court's decision, rejecting the complaining witness exception to absolute immunity that the district court relied on. Rehberg appealed to the Supreme Court, and the court agreed to hear the case and to consider whether a government official who presents false testimony as a complaining witness is immune from being sued for damages. Thank you for listening to this FantasyCast. For more information, please visit harlaninstitute.org or fantasyscotus.org.